Good evening. This is Rahul Reddy live from Houston, Texas. Reddy Neumann PC brings in immigration updates every week, Tuesday at 5 p.m. Central Time. Along with me is my business partner, Emily Neumann. Emily, what do we have today?
Thanks for joining us. Today we wanted to talk about a really important topic that's becoming more and more of an issue, and that is expedited removal versus withdrawing your application for admission. This is something that happens at the airport, at the port of entry, either when you're landing in the United States or at a pre-flight or pre-clearance inspection location outside the United States. So we want to explain a little bit more about that so you'll be prepared. We also want to talk about this idea of filing more than one H-1B registration in the upcoming lottery, what we call duplicate petitions. What do we consider a duplicate petition, and why do we advise not to do that? Because we feel like this could be an invitation by the Trump administration to trap people. We've seen it happen before, so we'll talk more about that. Also, yesterday, the public charge rule officially went into effect for all 50 states. There was some discrepancy with Illinois, but that is now cleared. So everyone has to follow this new public charge rule when filing an I-129, when filing an I-539, when filing an I-485, and also at the consulate when applying for the visa. So we'll talk about that, what the actual impact is for employment-based immigrants. And lastly, we want to talk about I-140 validity. We get a lot of consultations about what happens in the event of a job loss. You've had your I-140 approved, and it's been approved for at least 180 days. What can you do with that I-140 in the future?
Yes, Emily, now this expedited removal, particularly from the Abu Dhabi airport, and then we have seen Chicago airport, Boston airport, San Francisco airport, has become very common, particularly in Abu Dhabi airport. We have seen a lot of enforcement, certain misinterpretations, and certain times maybe they interpreted properly. And can you explain recently what happened in the airports, and if there is an option of, if the option is given to the person to either withdraw the application or should they withdraw it, or should they go for, I'm not going to withdraw my application. If you want to expedite remove me.
Mm-hmm. Okay, so what we're seeing is really a lot of scrutiny of previous F1 time. So this is happening when people are coming in on F1 again, but also those coming in on H4 and H1 who previously had F1 status. We're finding that we don't know exactly what is triggering the initial pull into secondary inspection, but people who are coming in, flying out of Abu Dhabi where they have the pre-flight inspection, or flying into Boston, Chicago, those airports, there is a lot of scrutiny of former F1 time. They're pulling people into secondary inspection, and they are looking at the phone, and they're looking through emails, they're looking through photos, and finding, based on what's in those emails, what's in the WhatsApp, what's in the phone, that perhaps there is something that was not correct during the F1 time. They're questioning the validity of jobs that were held during the OPT time. Maybe there was actually more unemployment than was disclosed to the school in the SEVIS system. We're finding people that worked without authorization, and they have pictures in their phone that show it, or they're talking about coming in for their shift in these WhatsApp messages, and that's tipping off the officers to something going on there. This has happened for students who maybe applied for University of Farmington and got involved in that whole mess. And so when you're in secondary inspection, the process is a very long process. It's very uncomfortable. You're there for hours on end. They pop in for an hour and grill you, and then they leave, and then they come back an hour later, ask you some more questions.
We're speaking about 12 hours,
yeah,
even more sometimes.
Hours on end. And all of that to get you to admit to doing something wrong. And so, when it comes down to the very end of it, if it's looking like they're not going to be admitting you into the United States, you kind of have two options. The first is you can let them deny your application for admission and put you through what's called expedited removal, or you can withdraw your application for admission and return to your home country. So expedited removal is a fancy way of saying deportation that is done at the airport not before a judge. It's done by the CBP officer right then and there at the airport. If you are removed under expedited removal, you are subject to a 5-year bar to coming back to the U.S. So that is why we would generally recommend that's not the option to go through. If you are given the opportunity to withdraw your application for admission, that means you're basically telling the officer, never mind, I didn't mean to apply to come into the United States, because when you're coming into the airport, you're not yet admitted into the country. Even if you've landed in the U.S., you are applying to be admitted. And if things go wrong, you can withdraw your application for admission and return to your home country. There's no 5-year bar for that. Depending on the circumstances, if there's no finding of fraud or misrepresentation, you may be eligible to apply for a new visa and come back if you can overcome the grounds for that, whatever was happening at the airport.
So Emily, there are two things. One is expedited removal proceedings and also withdrawal of the application. You're saying that it's better, probably based on the situation. Most of the time it might be better withdrawing the application rather than going to the expedited removal processing. Let me ask you this question. Have you seen any scenario where you think so that instead of withdrawing the application, the client should have gone through, okay, I'm not going to withdraw the application, you do the expedited removal proceedings?
Never. I don't think that's ever the best option.
So practically what you're telling is there is no legal representation at the time of entry into the country. If they are in a questionable situation, I mean, are you suggesting 99% of the time they should opt for withdrawing the application rather than going to the expedited processing?
Absolutely.
Because of the 5-year bar that you have, and now if you have been withdrawing the application, the visa will be canceled, but at least they can go and apply for the visa immediately.
Right.
Emily, in the situations where, have you noticed any increase in the expedited removal or the withdrawal of the applications recently?
Absolutely.
What is triggering it? Why Abu Dhabi Airport?
I think that part of what is triggering it is the information that's filled out in the DS-160 at the visa application point. Maybe there's some red flags there that the consular officer entered into that system, and CBP has access to some of that information. Anytime they see prior F1 stay, I think that's a trigger by itself. And it's just a higher level of scrutiny. I don't know why particularly Abu Dhabi compared to other places.
Abu Dhabi is considered as a port of entry, just like, it's a very rare situation that they've given in only for Abu Dhabi. It's not there for Dubai and other locations, but Abu Dhabi is considered that you're entering port of entry. Maybe they feel that it's easy to remove the people from there because it may be expensive to remove all the way from, let's say, Chicago, Atlanta, or other locations. That might be one of the things that I'm looking at. And some of the situations where we both notice, Emily and I notice, is that they've gone overboard and crossed all limits of legality in the way they questioned, in the way they interpreted the law, in the way they forced the individuals to withdraw application. Especially in the Abu Dhabi airport, we noticed that. So at this point of time, I'm suggesting all the people who are in the non-immigrant visa, if you are coming from Abu Dhabi airport, cancel the ticket, come from some other airlines. I would suggest you to come from the European airlines, do not come from any of the Middle Eastern airlines. That's in general suggestion, but in particular, avoid Abu Dhabi airport under all circumstances. If you are in a non-immigrant visa, just avoid. That's a better way of dealing right now. Emily, you said duplicate filing. Isn't duplicate, if I am getting an offer from one from Google and one from Amazon, can I not file 2 applications?
Well, when we talk to people that are, claiming to be in that situation, we usually discover that they don't actually have 2 offers from these actual employers. They have a second offer from a consulting firm that might place them at this
in the
other
past
company.
1 week, I got 10 people who told me that they got an offer from Google, and the second company kept on changing, Amazon and Facebook and Microsoft. So are you telling all these 10 people are wrong?
Yes. They're trying to get us to say, yes, it's okay to file more than one registration in the lottery. And we are saying, we've been telling people every year for I don't know how many the last years we've had this lottery, Don't do it. We see so many people that get into trouble because of it. It is not a minor thing when they're getting into trouble. They're getting their CAP subject approval that they thought that they could rely on revoked. And when that happens, number one, it puts you out of status. Number two, even if you've transferred to 10 other companies after that,
it's only the employer that gets into trouble. That's a rumor that's there.
Right. That's not true, because you're the one that's losing your status, and the whole thing just is a domino. They revoke that first one. Now it's as if you were never entered into the CAP. Now you're CAP subject. Well, guess what? Every single petition you filed since then was filed as CAP
all the other
exempt.
people are filing, Emily. Why should not I file it?
Because you don't want to end up 3 years from now with a revocation and put out of status, because you don't know what that company is doing with your information. That company might be submitting a fake resume somewhere, and that is exactly one of the reasons we've seen people getting into trouble in Abu Dhabi. When they're coming back in, they find a fake resume in someone's email, even if it was never submitted anywhere. If they find that, and we're finding sometimes it comes from an employer, there are employers out there that are not doing things properly, that are in violation of the regulations. They're filing speculative employment. They're saying they have in-house projects when there's no work available. I mean, you can look online and see, go to the employer data hub, see how many petitions these companies filed last year, and see how many denials they got. Look on their LCAs. You can actually look that up. It's publicly available information. See how many LCAs they submitted for their home office. 200, 250. You don't know what else these companies are doing with your information and how many other people they are sponsoring. And guess what? When that company gets into trouble, they just close up shop and run away. Open up another
made their
company.
money.
Yeah, they're done. So, and you're the one left holding the bag. You're the one that is going to lose your status. You're the one that's going to lose your CAP exemption. And now it's as if you've never filed in the CAP before, and you've been out of status for what, 3, 6, 9, 10 years. By the time it's all said and done, it's just not worth it.
I'm practicing immigration law for more than 23 years, and this is my serious thing right now. This time, unlike all previous times, the USCIS is promoting for you guys to commit fraud. That's so simple. Because $10 is not good enough to prevent the fraud. Previously, when they were filing the application, they have to shell approximately $1,500 to about $7,000 for each application. That was one of the hindrances, though. Even though we have seen so many people filing the fraudulent applications getting into trouble, every single week we get a notice of intent to revoke for the applications that have been filed in 2016 and 2017, and they come and ask, what's the solution right now? Because in 2016 and 2017 they filed an in-house project, and now they're not even working for that company. Unfortunately, there is no solution. It's all gone. That guy packed up, made his money, and left the country, and you are here to trouble. So my suggestion to you is that do not file duplicate applications. There are lawyers that are promoting the duplicate applications. There are employers that are promoting it. Do not file duplicate applications. You will be in trouble. All the people, how can 10 people in past 1 week have offer from Google? And I got a little bit, wow, how come all these people have offer from I told that guy, can you send me the copy of the offer letter that you got from Google? And that guy says, oh, actually, it's not Google. It's the consulting company says they have a project at Google. There you go. So we are under extreme pressure from a lot of people to tell the world that you can file the duplicate application. They are asking questions in different ways. The answer is still no. No duplicate filing. If you, Mr. John Doe, is filing from 2 different companies, even if they are not separate companies, be wary of it. It may not be legal. You may be in big trouble. And please don't file duplicate applications. This time the USCIS is inviting you to get into trouble so that they can throw you all of it. Look what happened. The USCIS opened an office called University of Farmington. They hired recruiters to get the people to get the student visa so that they can throw off all these people. Now imagine this $10 thing is such an easy thing to throw you guys out. So please don't file the duplicate applications.
Yeah, and think about this. When your employer is registering on your behalf, now it's in an electronic database. Before, it was a physical petition. We knew they were doing some data entry on that, but now that company is entering your name, your passport number, your date of birth, your gender, your country of citizenship, country of birth. All that information is at USCIS's fingertips. You think they're not going to match it up with other companies submitting the same thing on the same person?
They are.
It's so easy for them.
They are
to
looking
track
into
people
all
now.
WhatsApp applications, emails, even if they don't open it. You think so that when you're sending the application to them, they're not looking at it? You got to be kidding. I mean, you should not be an IT profession if you're thinking that way. I don't know which other profession you might be, but if you're an IT profession, you think so they don't know how to look into matching those things, I guess you shouldn't be an IT profession. Emily, on this public charge rule, last week you explained, Chicago is different and they stay here and all those things. What's the rule now? It's changed from last week to right now?
Yes.
I mean, it just came out on Monday. I mean, Monday was the effective date.
Yeah, so Friday we learned that the rule will be effective for the state of Illinois. So everybody, regardless of where you live, if an I-129 is being filed, there's a new page in that form that asks about use of public benefits. I-539, regardless of where you are, there's a new page in that form asking about public benefits. I-485, there's an entire separate 18-page form.
Did you say 18-page form?
18 pages that you have to submit, not only for you, your spouse has to submit one, your children have to submit one. All of these are required as of yesterday, regardless of where you live. Now, generally, we assume that most employment-based immigrants and non-immigrants are not likely to be subject to the public charge ground of inadmissibility. It's very unlikely that they've used public benefits in the past or they will in the future. So this rule, in reality, it's not going to end up with thousands of non-immigrants in the employment-based categories denied. What it is going to do is require extra hassle factor. Now your employer, of all things, on the I-129 has to the employer is certifying that you have not used benefits, number one. And number two, I would highly expect USCIS is going to cross-check that with the various government agencies involved in issuing these public benefits. That is going to take more time. So all of this is going to boil down to longer processing
So this
times, more
18-page application should be filed by the main applicants or even the kids too?
Yeah, every single person.
So even the kid has to disclose all his assets, like 6-year-old guy has to disclose all the assets?
That's the latest information we have. Now
if there is an Xbox, he has to list. What if it's just a $5 toy? You still need to list it?
Yeah, great questions. There is a public engagement coming up soon where we have the opportunity to ask questions about exactly how they're implementing that. I mean, they haven't even put out what the standard is. How are they going to actually assess whether your 944 form is good or it's bad? Is there a mathematical formula? Do you have to have a certain income? No, it's just these positive factors and negative factors. So the officer has discretion to decide. That discretion can't be arbitrary. It has to be set according to some standard. So there's just no information. We have no idea how these officers have been trained to review that information. It's going to be a rocky road.
But keep tuned in. We will update you all the information. As of now, everybody has to go through this public charge thing, and also in the consulate, also they will have to go through. And if the consulate feels that they need some extra information, they will ask all the assets and liabilities of that particular person before granting the visa. So it's a lot of paperwork. You'll have to face the paperwork and be prepared for delays due to this. Emily, on the I-140, after the I-140 is approved and 180 days has been passed, and the employer has not withdrawn by that time, what can he do with this I-140?
Yeah, this is a huge benefit that came about from the January 17th, 2017 regulation. That basically says that once you have an approved I-140 that's been approved for 180 days, even if the employer withdraws that I-140, you can use it to keep your priority date. You can use it for your spouse to continue to get H-4 EAD extensions, and you can use it to continue to get H-1 extensions beyond the 6-year limit with any company until your priority date becomes current. So you can keep getting those 3-year extensions. You can do this outside the U.S. You can go outside the U.S. for 10 years And 10 years from now, if your priority date is still not current and you have a new company that wants to sponsor your H-1, they can do it. Consular processing, as soon as it's approved, you get your visa stamp and come in and now have a fresh 3 years based on that I-140. So it is a very beneficial rule that came out. It wasn't as great as what we thought it might be, but there is a lot of benefit. The only thing you can't do with that I-140 is use it to actually get the green card when your priority date does become current. So at that point, your new employer should have filed a new labor and new I-140 for you.
Emily, what if the employer withdraws after 180 days?
So it is withdrawn. So the I-140 does not remain valid for purposes of you getting the green card because that job offer is no longer there. But you still can use it for continued H-1 extensions, continued H-4 and EAD extensions, and you can keep that priority date on any future labor and I-140 you file.
Let's go to the question and answer assembly. Ganeshan from Facebook has this question. On the I-140 application, he has his I-140 approved, and what is he's applying for the H-1B visa. If he applies, what does he need to fill out for the DS-160? As an immigrant visa has been applied for? Yes, he can answer yes to that question. Since he's applying for the H-1B, it will not affect whatsoever at all for him to get the H-1B visa. H-1B visa person can have an immigrant intent. It's not a bar for them to get a H-1B. It may be a problem for the people for F-1 and also for the B-1 visa, but not for the H-1B visa.
Pavani from Facebook wants to know if standalone H-4 EAD applications are taking as much time as an H-4 extension plus EAD application. So we're talking about the difference of filing the I-765 by itself, where you already have valid H-4 status, or filing the H-4 extension, the I-539, along with the EAD extension on the I-765. So the H-4 EAD filed by itself, just the I-765, does have a slightly faster processing time than the I-539 processing time, because the I-539 has that fingerprint requirement, which caused all of our processing times to go way beyond normal. So we've had several people that, rather than filing the I-539 along with their spouse, with the H-1B extension, they wait until the H-1 extension is approved, go out, get the H-4 stamp, and then come back in and file the EAD by itself, just to save a little bit of time. Definitely more hassle that way, though.
Lukeman has this question that his family's H-4 has been approved until June of 2020. Now he moved to company B. Do they need to file the H-4 extension before June 2020? They are in USA right now. The answer is yes. They need to file before June 2020. If they don't file before June 2020, they will be considered to be unlawfully present in this country.
Uma from Facebook has another question on H-4 and EAD. So in her case, she filed a change of status to H-4 along with an EAD back in 2018. Instead of waiting for it, she decided to leave and get the H-4 stamped. And now, all of a sudden, her EAD case status is saying that it's been approved. New card is being produced. So what do we do from this point? So because the I-539 application, the H-4 application, was a change of status, so I'm assuming you were in some other status and filed to change your status from that status to H-4. When you exit the country while a change of status is pending, the change of status is automatically abandoned. That means your I-539 is automatically denied. It doesn't happen right when you leave, but by the time they get around to adjudicating that application, the I-539 is supposed to be denied. Now, it sounds like possibly in your case it was mistakenly approved, and you cannot rely on an approval that was issued in error. So because the I-539 should have been denied, that means the I-765 should have been denied. However, do you think, would you rely on that EAD card? I mean, an EAD card is valid until it's revoked.
Yeah, I don't see any reason.
I don't see any reason not to rely on the EAD card, but you do need to have, obviously, the new H-4 stamp to come in. That EAD itself, you lucked out on that because it normally would be denied.
Yeah. Sharath has this question. His H-1B is expiring in June 2020. He filed an extension, got an RFE. Now he's considering of moving from employer A, whose H-1B is through which the H-1B is expiring in June of 2020, to employer B. Will it be a problem if he applies the change of employer while the extension is in progress? The answer to you, Sharath, is no, it's not a problem. The only reason is because your I-94 has not expired. It is still valid until June 2020. If you're speaking in July 2020, it's a different issue though. Since your I-94 is still valid, you can apply for change of status. Having both of them at one point of time is not a problem. The only time we don't promote the two applications together is the lottery, because people are trying to circumvent the lottery fraudulently. In your case, you're perfectly fine, absolutely no problem.
Sai from Facebook has a question about the 60-day grace period following a job loss. So in his situation, he lost the job, but actually continued to receive severance pay for several months after that. However, his employer, the previous employer, did inform USCIS about the job termination, so the H-1B approval has already been withdrawn. And so now he's looking to file an H-1 transfer and wants to know when exactly does the 60-day grace period begin. So there is no guidance on this. So generally, we just do our best to make an argument. So in this case, I would say that because you were still getting the severance pay, you have paychecks to submit. I would say the grace period started counting from when the H-1 was withdrawn on February 11th. And so because you're filing within the 60 days from that date, you should be eligible to file the H-1 transfer. It's all about, can you make a valid legal argument based on what is actually in the regulations? And because the regulations are silent on this issue, there's nothing saying you can, but there's also nothing saying you can't. I would make the argument.
Jay has this question. His change of status got denied. He hasn't received the approval notice without the I-94. It's been 3 weeks. How much time it takes? When does he need to depart? One of the major issue, Jay, is that if the change of status has been denied, there got to be a reason why the change of status is denied. The only thing that I can think about is that according to the USCIS, you didn't maintain the legal status. That's the reason why your change of status has been denied. I would recommend to depart as soon as possible. Now, if you don't have the original H-1B approval, you can still go for stamping. We have seen that it's not a problem. But the major issue that pops up is how are you going to determine when the expiration date of the H-1B is? So you can call the USCIS, maybe they'll give you the expiration date. The employer or the lawyer can call the USCIS, they might give an expiration date. Based on that, you have the file number, you can make an application with the consulate and go. You should be fine, and we haven't noticed that any problems when the people are going without the original H-1B approvals there. But it's absolutely essential that you leave the country as soon as possible.
Gautam from Facebook has an H-1B that is still pending from last year's lottery due to a couple of RFEs and wants to know if another petition can be filed in this year's lottery, if he can be registered again. So yes, assuming the job is still available, the same employer can submit a new registration this year, and if it's selected, the employer can file another petition on your behalf this year. Once you're filed this year, this is what's going to happen, at least based on my experience. At some point, when they're getting ready to look into this year's application, they're going to see that last year's application is still pending, assuming it's still pending at that point. They will then likely send a notice on the new application saying, we're putting this application on hold. They're putting it in abeyance. Because you have a previous application pending, we're not going to take any action on the new application until a decision is made on the old application. Once you get to that point, you kind of have some options. You can either choose to wait and see what happens with the old application. If it gets denied, then proceed with the new application. Or you can withdraw the old application if you think the new application has a better chance of getting approved, and then let them know that the old application has been withdrawn. Please proceed with the new application. I'll warn you, in that second option where you withdraw the old one, it takes quite a long time for them to figure out what exactly is happening. I had to upgrade to premium processing and then contact them every other day for about 3 weeks with the same information that the other one has finally withdrawn before they would finally take action on it, and then it took another 15 days to process.
Ashutosh from YouTube has this question. His wife has gone to the university for a semester and then she just quit going to the university. Does she have to mention the university name in the DS-160? Yes, it is an absolute necessary that you need to mention the university name. Even though you never applied for the F1 visa, only one semester has been gone, it's absolutely needed for you. We have noticed sometimes when the people did not mention, especially in the consulates in in India, US consulates in India, they have said that you're misrepresented because you did not list the university name when you went to the university. It's very dangerous not to list it. You should list it. Sohail, Emily, I need your attention on this question from YouTube from Sohail. Since there is no LCA approval required with the electronic, will it not flood with a huge number of unapprovable cases and reduce the chances for others?
Absolutely. That's exactly part of the reason why we're telling people don't do these duplicate filings. That's exactly what we're expecting.
So you're
to happen.
telling all other people, you're telling Suhail, who is a nice guy, he's not going to file, but all the bad people are filing. How is it going to benefit Suhail?
It doesn't, unfortunately, but at least you can sleep well at night, I guess.
And then Suhail, and also that we are expecting this time the USCIS is going to take action on these people. Believe me, because with so many number of things, it's going to bust out and people are going to complain against each other, which they should. If they're doing somebody's doing fraud and you know that company did it, go ahead and comply with the USCIS. That's going to get your number up though. I am expecting at this point of time the fraudulent applications will be up and they're going to do another lottery for the people who have applied only one time. This is going to happen. That's my expectation. If it doesn't happen, Sohail, though, I, among a lot of other people, are going to complain against the companies that have filed for the duplicate applications. I hope you will join me in complaining, and there is in our RN law group, there's a provision where you can you have all the information where to complain, how to complain to the USCIS or ICE. We have provided that at RN law group.
Olaraku has a question. He has an H-1B approved, I-485 pending, and an EAD and AP. Wants to know if he can travel outside the U.S. So because you have H-1 status, you have the option of going out and having the H-1B visa stamp and coming back in H-1 status, or using your advance parole to return to the U.S. I think the answer to which option is better really depends on a couple of factors. Number one, do you have the H-1 stamp already? If you do, my suggestion is stick with the H-1 status because it provides you a backup plan in case something goes wrong with your 485, especially if your I-140 is also still pending. If there's a risk of an I-140 denial, that's going to cause the 485 to be denied. And if you don't also have the H-1B status active, you're going to be immediately out of status. And if you don't leave within 30 days, you're subject to the NTA memo that says they can issue a notice to appear in deportation proceedings. Now, if you don't have the H-1 visa stamped, you technically could use your advance parole to return and avoid getting the stamp because people are also having problems with 221Gs and delays administrative processing at the consulate. But definitely you should talk to your attorney before making any travel arrangements to assess which option is best. Is it better to go for stamping and potentially have a risk of administrative processing and getting stuck there? Or is it better to use the advance parole and forego the H-1B, and take on the risk of the 485 potentially being denied?
A person from YouTube, I don't want to name him, actually had a consultation with him, is saying that an I-140, can it be approved from a hotelier who runs a hospital corporation and use it for my IT employer? The one thing is that does the hotelier has a job for you? If so, what does job he has? Is it a permanent job? I doubt whether he has a real job there. If he doesn't have a job for you, he should not be filing an I-140 for you. The whole thing is a fraudulent thing. There are two questions that are very good questions that came out on the public charge thing. I don't think so I have an answer, but I need to raise this. One from Mr. Ghosh. is that he has a H4 child with autism, not a U.S. citizen. He has some behavioral, speech, occupational therapy, and other things going on. Medicaid program, is it going to affect him?
It should not. I mean, that
He
is
is an
not.
the kid is
I
H4.
understand that, but this is not an income maintenance program. This is different. There's actually, I don't know if you're on Twitter, but I shared a flyer from AILA, the American Immigration Lawyers Association, that very clearly spells out what does not qualify as a public benefit. And I feel 90% certain that something like this, when it's a health-related issue, that it should not, it's not an income maintenance, that it's not food stamps, it's not WIC, it's not housing assistance, it's not TAMP. Those are the ones that they're looking for. They're not looking at the ones where you went to the emergency room or something like that. But I'll try to find that and post, maybe we can get it posted on rnlawgroup.com, but it is on Twitter. If you follow me at Immigration Girl, I posted it within the last day or two.
Mr. Ghosh, keep trying to follow us, because this is a developing law. We would like to keep on, update the things on those things. So please keep following up on that. And then this is a sensitive issue. We would like to, if necessary, if within 2-3 weeks you don't get an answer, drop an email. I will give a free consultation to you, so to guide you on what is our opinion from 3 weeks from now. What about the person who is declared insolvency? What are his chances of getting the extension and getting the green card?
Well, I mean, the I-129, the I-539, the specific questions they ask is, have you used public benefits? So that doesn't seem to be relevant.
That's not a public benefit.
Now, when you're filing your I-485, then you have to fill out the 944 form, and that's where you have to list all of your assets, all of your liabilities, your credit score, your credit report, your tax transcripts, your proof of health insurance. So according to how all those numbers come out, very well could be an issue for the green card approval.
But for Indian nationals, it's a long time for them to get the green card, and by that time, maybe this guy has a lot of assets. So.
Potentially, yeah. Kishle from Facebook wants to know if it's safe to go for H1 and H4 stamping in Mexico, where you have the I-797 approval with USCIS, or is it better to go in the home country? So generally, when you've already received an H1 or H4 stamp in your passport in your home country and you're applying for the second time around, Canada or Mexico are generally fine for that. We've had a lot of people choosing to go to Mexico for both H1 and L1s and L2s and H4s in the last few months, just because it's so much more convenient and a much faster, smoother process we're finding compared to some of the consulates in India where everyone gets stuck with the 221G.
Swati has this question. She's in adjustment of status right now. Does she need to maintain the H-1B? She already lost the H-1B. Does she need to file the H-1B and get it stamped in India? Swati, my personal recommendation is no. I would not get back on H-1B. There are some people who advocate, I don't know, I am of the opinion that no, you don't need the H-1B. There are some pluses to having an H-1B while you have a 485. There are some minuses having an H-1B. Sometimes if your H-1B gets denied, it goes into the record, and the USCIS officer is looking into your 485 application and saying, hey, why is this H-1B got denied? So there are some minuses though. So overall, having an H-1B is more minus point than plus point in a 485 application. I do not recommend anything.
Barath from Facebook wants to know, he received paychecks during his paternity leave, and his employer had signed him up basically for short-term disability, and he received that and wants to know if that is a public benefit. So generally, short-term disability is a benefit that you and your employer contribute premiums to an insurance company, and then when you use those benefits, it's based on money you've already paid for that service. So that is not a public benefit. It's not coming from the government. It's not for income maintenance. So based on the information you've provided here, it does not sound like that would be considered a public benefit.
Mr. Prasad has this question. Is the green card holder subject to the public charge rule? One thing is that this public charge rule, as it is getting interpreted by the Trump administration, is nothing new though. It's been already there. All he's trying to do is implement it in the way he is doing it. So if you're a green card holder and you have taken the public benefits though, depending on what kind of public benefits, it may affect your citizenship application. It may affect your current green card application too, green card too.
Praveen from Facebook, his wife is on H-4 EAD, but she had an H-1B 4 years ago. He wants to know if she can switch back to H-1B without going through the lottery, and if yes, is there any time limit that you have to use the rest of your H-1B status? So she can switch back to H-1B at any time without going through the lottery, and no, there is no limit. There is no time period you have to use your remainder option. So even if it was 10 years ago, if she has 4 years left on that 6-year limit, she can change status back to H-1B 10 years from now and get those remaining 4 years. There's no time limit on that.
Ekalavya from YouTube has this question. He's an O1 visa. His EB1 AI-140 has been approved. His priority date is 2019. I'm assuming he's from Indian national. He's an Indian national. And his O visa is expiring of June 2022. Do you suggest to change from O1 to H1B? Good question. Yes, the answer is clearly yes. Do H1B. One reason is that the O1 visa is a non-immigrant visa. And with a non-immigrant intent, it may have some difficulties facing. Although there are some exceptions available, we have noticed that they're a little bit fine on extending the O1 visa. Safer thing is to move to H1B, because H1B you can have an immigrant visa and you will not have any problem in getting the H1B and extension of the H1B. We don't know how long it's going to take for people to get the priority date current if your priority date is October 2019. Emily, there's another question that came out is that what about Senate 386 bill and 1044 bill? Any update? Because these are the things that are causing problem for the people.
Right, yeah, I have not seen any updates on.
No, right now it's in the midst of the primary elections. Maybe after the Super Tuesday is over, maybe things get up a little bit easy. So not much is going on at this time.
Busker from Facebook wants to know if he can change employers after his I-94 expired, but his extension is still in progress and he has an approved I-140. So the pending extension keeps you in a period of authorized stay and allows you to continue to work for up to 240 days. Technically, yes, you can file a transfer based on that pending extension, but most likely when they finally get around to adjudicating your transfer, if the previous H-1 extension has been denied or withdrawn or is still pending, your transfer is going to be approved without an I-94 card. That means you're going to have to exit, apply for the new visa stamp, and come back. So generally it would be better to wait until your extension gets approved and then file the transfer, or have the other company file the transfer requesting consular processing, and as soon as it's approved you can go get the visa stamp and come back in.
One rule that Praveen is asking question that what happens if the I-485 is approved but priority date is not correct? I mean, that's not a good question at all, because that cannot happen. If by any chance it happens, it's a complete error by USCIS. Go back, give the green card back to them and tell them to put it back in adjustment of status, because that cannot be done. And if by any chance they accidentally do it, they are going to revoke your green card later on. It's better to get it done right now.
Vikas from Facebook says, if an H-1B petition has been approved for a 7th year extension based on a pending perm that's due to an audit, what happens to that approved 7th year extension if the perm eventually gets denied? So nothing. That H-1B approval remains valid for that 1 year period until it expires. It doesn't disappear just because the perm eventually got denied.
Akilanand has this question from YouTube. He has received a 221G and went to the H-1B stamping. Does it mean he has to answer the question, was your visa ever been rejected? No, you just got 221G. You never got the H-1B denied. So you don't have to answer yes to that question.
I think I disagree. The
Okay.
221G notice itself says this is a denial, and many of the consulates actually say that you have to report this as a denial. It's a temporary
Really?
denial that can be overcome.
I
I
take
think
that.
it is a gray area, but yeah, there is some information out there suggesting that
Thank you.
it
It's
is
always
a
good.
denial.
I get corrected. That's good. So 221G people. So even if they didn't get the visa denied, they have to mention that.
Right. If they got a 221G and then later got the visa stamp, it's still considered a denial, which doesn't make any sense to me. But
Oh, okay. That's a good thing to learn.
Prakash from Facebook wants to know if a perm has been filed but not yet approved, and then the H-1B runs out of the time on the 6-year limit, can we travel outside the U.S. and then once the perm and I-140 get approved, file an H-1 to come back? So yes, you can do that as long as the priority date is not current at the time you are trying to file that H-1 extension outside the U.S. based on the approved I-140. If the priority date is current, then you don't have that option.
Samrat has this question that can he travel outside for 1 or 2 days on H-1B, especially he has a Canadian green card to get it. While the enrollment is in progress, can he come back by March 27th? That's a very tough question. Based on what the other way that you have a green card that you're getting it in Canada. We are generally recommending people not to travel because when you come back on March 27th, what are you going to say to the port of entry? That you're coming back on a student visa, or are you going to say that you're going to come on apply for the H-1B? As of now, we have not seen them denying entry for the people, for example, if their H-1B has been selected in the lottery. We have not seen them denying the entry, but you are asking for trouble. You never know how this administration is going to act upon. If you intend, because it's a very sensitive thing for you, that you want to travel because of the green card that you're getting there in Canada, I understand that, but I would recommend that you make an appointment with a lawyer to make sure to evaluate yourself how you're going to act if the CBP official asks the questions. You should be prepared for those things when you go.
Sukesh from Facebook wants to know what happens to an H-4 EAD if you switch from H-4 to H-1B and then say later back to H-4. Based on our research, that EAD is still valid. Now you can't work on using that EAD while you're in H-1 status and say work for your H-1 employer and then work on the EAD for another employer. That's not an option. But if you do convert back to H-4 status and that EAD hasn't expired, EADs generally remain valid until they're expired or they're revoked. And we've never really seen USCIS go back and revoke EADs for people who are on H-4 and converted to H-1. So it should still be valid.
Jutu has this question from YouTube. He has a LCA as his home address. Now he moved to a different place, which is within the same MSA. He meant county, but I'm assuming within the same MSA, within the nearby area. Does he need to file a H-1B amendment? The answer is no. You don't need to file an amendment. Since the job is same, you just changed within the same MSA location, you don't need to file an amendment.
Heymonth from Facebook wants to know what our thoughts are on part-time H-1Bs. So we do these from time to time, most commonly when someone already has an H-1B with one company for full-time employment and they want to take on a part-time position with another employer. We file what's called a concurrent H-1B for part-time employment. Never any issues with that. It's treated just like any regular H-1.
What if it's not a concurrent and then you just want to,
yeah, that's what I was just about to get to. So if you're just going to work part-time for the one employer, you have to be very careful about the public charge rule, about possible grounds of inadmissibility because you can't support yourself. So you have to look at what is the wage that's being offered by this company. Would it be clear to USCIS that based on the number of hours you intend to work and what the pay you're going to receive, will you be able to support yourself financially? So if you're going to work 30 hours a week and the pay is more than sufficient to support someone, should not be any issues. If you're looking at 5 hours a week, making, much less money, that's probably going to be problematic.
Question that comes up from Bharat from Facebook is that, does the 240-day rule apply for the H4 extension? No, it does not. I mean, there is no 240-day rule. The 240-day rule is only for L1 and H1 when their extensions are pending for more than 40 days. They cannot work beyond the 240 days. They can continue staying beyond the 240 days, but they cannot continue working after 240 days.
Ahmad from Facebook says his perm is in progress, and initially it was decided that they would be filing the I-140 and EB3 category, but he knows now the rest of the world category for EB3 has retrogressed, and he wants to know if he should now talk to his employer about possibly reconsidering and filing an EB2. So number one, if your perm is already in progress, the only way generally to move from EB3 to EB2 is to start a new perm. So that's one thing to consider, is that you're going to be starting over from scratch, so there's already going to be added delay from making that change. On top of that, I don't think this current retrogression in EB3 is going to be lasting forever like some of our other categories. It generally, I don't know your thoughts on this, but it generally should come back to current in October. We also have the filing dates versus the final action dates, where you may be eligible to file the 485 early even if the green card is not yet available. So I don't know if I would go through the hassle now of redoing everything to get into EB2 just because EB3 retrogressed right now.
San has this question that he has gone to the day one CPT university and his H1B is approved right now. Does he need to list the university and also the employer information? Which one he needs to list in the DS 160? You need to list both. One as an educational institution that you're going to, one as the university. As of now, we haven't seen consulate giving much problem when you list both the things though. Maybe there will be a time where they'll say, have you been going to the university? They may challenge it. But at this point of time, we haven't seen that much.
Okay, Venkata from Facebook is asking for a friend. This is a H-1B amendment that was filed 2 years ago and finally just got an approval that was backdated and has already expired. So he wants to know what the options are. So going forward, I would say, if you're just now getting an approval on a case filed 2 years ago, that should have been upgraded to premium processing a long time ago. Avoid that whole situation because the case was pending for 2 years. But because the approval has already expired, at this point, you have to look at, is there a potential unlawful presence issue? There's definitely out of status issue based on this. I would need to know more information to figure out exactly whether traveling is going to trigger a 3 or 10 year bar in order to clear this up, or if it's possible to file a nunc-pro-tunc extension, basically claiming that there was no way you could have possibly complied with the requirements because they issued a backdated approval notice. So just not enough information and too many variables to really answer that question.
One question that came out from Sukesh from YouTube is that his H-1B was picked up when he was in India in 2016, but he never went for stamping until 2018. He only got the stamping for 1 year. Then he extended the H-1B for 3 years. Can he still apply for the rest of the 2 years that he didn't wait for the stamping? Sukesh, if you are not present in United States on H-1B, you are not counted towards a 6-year period. So the first 2 years that you did not get stamped when you're in India, that is not counted towards the 6 years at all. So you can easily claim the 2 years, absolutely no problem. But Sukesh, it's better that you try to get an I-140 as soon as possible, because you don't want to go use the 2 years and then complain that you want to stay for a longer period of time. So try to take the I-140 action right now.
Muni Kumar from Facebook wants to know if when you're transferring an H-1B to the different company, is it recommended to file the H-4 application along with it if the H-4 has continued validity for some time? Even though the H-4 might be valid for some time, there are some reasons why it's beneficial to go ahead and file the H-4 along with the H-1B extension. The main benefit is so you'll both have the same end date. It's happened so many times where only the H-1 gets filed and people forget that the H-4 is expiring at a different time, and then we come to find out too late it's already expired. It's very difficult to get that resolved. So that's really the main reason why I like to still include an H-4. Now, if the H-4 is traveling and you know they're going to be exiting the country before the current stay expires, then really there's no reason to file it. They can, while they're outside the U.S., take your H-1 approval notice with your new employer, go for stamping, and come back in and get the extended validity period that way. So it kind of depends on the specifics, but main reason is to have the same end date.
Question that came out from Soumya from YouTube is that her friend's H-1B has been cancelled at the port of entry. Can she apply from a H-1B from a different employer and come back into the United States with the H-1B stamping? The answer is not easy. The question, as we presented in the early part of this video, was that did she withdraw the application or was she denied, was she expeditedly removed? If she's expeditedly removed, she has a 5-year bar coming back into the United States. She needs to get the waiver before she can get anything done. If she has withdrawn the application, there is a sheet that they normally give it at the airport. It's, I think so, I-877, I can't remember the number. That sheet needs to be reviewed by a lawyer to see what are the statements. Why was she denied? Why was she forced to withdraw the application? What are the statements that she has said? What if she has said that, you know, she has been arrested a couple of times for DUI and then she has been sent back? We don't know what the content of it is that. What if she has been illegally working in the United States? What if she has done some wrong things? So all those statements will be there in that, and she needs to consult with a lawyer, and she needs to be very careful in what she is answering when she applies for the H-1B visa back in the consulate. This is the reason why she has been denied entry. She needs to be very careful when she is going back. I would have it reviewed by a lawyer. I would have the DS-160, that's the application that you fill when you apply for the visa, again reviewed by a lawyer to make sure that there are no contradictory statements that what has been said before at the time when she is trying to enter the country and what she is stating. And if there are any contradictions, for example, the CBP officer believed differently and she believes it differently, then it needs to be clarified why she is right and why the CBP misinterpreted those things. And she needs to be trained and need to have a mock interview done before she goes to the consulate. Please don't take these things simply and destroy your families. Have these things, you know, before you go to the consulate. My advice is to get a mock interview done by a lawyer. Have the lawyer review the entire H-1B application. You know, make sure that, you know, your Facebook, your YouTube, Facebook, LinkedIn, and other things are updated with the proper employer, proper information. These are the common things that you can get, you know, these are the simple things that you can take care to avoid the pitfalls that people normally fall into. It's getting very tough, guys. I mean, I've been doing business immigration from 23 years. It's getting tougher and amount of denials. I mean, getting the H-1B approval, especially in 2017 and 2018, became a very tough job. Now in 2020 seems to be that day one CPTs and now port of entries, consulates are giving problem. One person did not list the university that they went to. And they denied, not only they denied, they said that this lady is trying to misinterpret it. This lady's misrepresentation has been done, material misrepresentation. She can never come back into the university just because she didn't list it in the university. So these are the things you need to be careful. Don't take it in your hands. Be careful before you go to the USCIS or to go to the consulate or CBP officials.
All right, well, I think we're about out of time for today. So thank you everyone for joining and asking all of your questions. We hope you find this helpful. If we weren't able to get to your question, you can join any of our daily conference calls. Those are for free, and you can go to rnlawgroup.com to get the schedule and dial-in information for that. If you'd like more detailed information about your specific situation, we would recommend setting up a consultation with either of us or any of our other well-qualified attorneys who can answer those questions for you. You can go to rnlawgroup.com and click on consultation. There you'll see all of our schedules, be able to choose the attorney and the schedule that works best for you. And you can always follow us on Twitter at rnlawgroup, or I'm at Immigration Girl, and you can join immigrationgirl.com as well.
Thank you guys for logging in.